Everybody, and welcome to the first of our afternoon sessions here at our conference. Good to see you all here. It's a very great pleasure of mine to introduce my friend Leo Linbeck III, who will be our speaker here this afternoon. It's kind of a daunting task to introduce Leo Linbeck to a crowd. In fact, I was with him last night as someone came up to us and asked him what he did, and I saw Leo himself actually be given pause as he had to think about how to describe his professional activities. It's not that Leo is idle, it's more that his professional endeavors are as multiple and as varied as his talents. You can find Leo, I'm sure, on any one day holding a meeting at his company, Linbeck Construction Company, located in Houston, Texas, of which Leo is the CEO. And probably later that afternoon you may find him taking a call from the revered Broadway producer Stuart Ostro, who is the producer behind the Broadway hit 1776 and Pippin, and was also involved with The Music Man, as both Leo and Stuart are involved with what you might call, and Leo I'm sure will tell us more about this, something of a think tank for musical theater called the Institute for Advanced Study in Musical Theater. Leo is also an adjunct professor in the MBA program at Rice University, and amidst all this activity and leading all this activity, he's of course a wonderful father to 3 beautiful children and 1 on the way, which I'm learning. So we're welcoming Leo back to Notre Dame. He received his undergraduate career here at Notre Dame. Again, you won't be surprised to learn, given what I said, that he was a double major in engineering and the program of liberal studies. I think that gives you something of an entree into the mind of Leo Linbeck. So I give him to you now as he speaks on the topic, First, Kill All the Lawyers, Intellectual Property and the Re-Feudalization of Culture. Leo Linbeck.
Thanks for the opportunity first to speak here at this conference on Epiphanies of Beauty. And I admire Dan for inviting a non-academic, non-artist to an academic conference on the arts. That's truly outside the box thinking. A little bit more just to touch on my background so you have a context. My family's business, Linbeck Group, is a construction organization. I'm the CEO of the parent. We have other operating businesses as well. And but one of the things that Linbeck is great at is working with the very best architects in the world. We've worked in recent years with Philip Johnson. Tadao Ando did his museum, Modern Art Museum in Fort Worth. Michael Graves we're doing a commission right now with, and Sir Norman Foster we're doing the new Opera Hall in Dallas. And we work for Harvard, Yale, MIT, Rice, TCU, and just about every institution in the medical center in Houston. So I started off my career at this sort of intersection of art and commerce, and then I was involved for about 7 years with an organization called Next Stage Entertainment. I was the president and CEO, and that's where I met Stuart. And Stuart is a pretty remarkable guy. Next Stage ended sadly in bankruptcy, once again proving the only surefire way to make create $1 million entertainment business is to start with $2 million. But the relationship with Stuart has endured, and I'm going to talk a little bit at the end about this. But my background and my practice in the arts is as a practitioner on the business side. I am not an artist, and although I play one on TV. So let's talk about, here's what I wanted to go through today in terms of agenda. I have 3 Simpson stories that I want to start with, which is, again, offbeat to say the least. Then I want to go through 4 musings and a model. Then I'll wrap up, and then if there's time left, get to some Q&A. So first, my first Simpson story. I'm not a big believer, even though the conference is on post-Christian culture. I actually don't believe there is such a thing. Don't believe there can be, because that sort of implies the end of Christianity, which I have a problem with. But if there is a post-Christian culture, certainly its archetype is The Simpsons. So I want to share a moment of this. Actually, it's a sizable clip because I want to give you the full picture of this. One of my favorite Simpsons episodes is one called A Streetcar Named Marge. Some of you may have not seen that, in which the lovely Marge Simpson plays Blanche Dubois in a musical adaptation of Streetcar Named Desire, known as Oh, Streetcar. And I have here a clip which I think gives you a sense. Let's see, hopefully.
Run away.
Yeah.
What's the matter, honey? Are you lost?
I'm looking for my sister, Stella. It's Mom!
Huh?
My name is Blanche Dubois. I thought my life would be a Mardi Gras, a never-ending party. Ha! I'm a faded southern dame without a dime.
I'm collecting for the evening stars.
Come here. I want to kiss you just once, softly and sweetly, on your mouth.
I am just a simple paper, no romance do I seek. I just wanted forty-cents for my deliveries last week. Will this bewitching bluesy seduce this humble bluesy? Oh, what's the paper's for it?
So sorry.
Hear me yell up, you put me to hell, Stella, Stella!
Ooh, she can fly. I think it's supposed to symbolize her descent into madness. Whoever you are, I have always depended on the kindness of strangers.
You can always depend on the kindness of strangers who come up experience and shield from danger.
Now here's a tip from Blanche you won't regret.
A stranger's just a stranger. You haven't done.
Which he de rigueur exclamation points. So that is that is wonderful, isn't it? I mean, it's clever, it's urbane, multicultural, it's ecumenical, mocking of flyover states in the manner of waiting for government. I mean, it's all there. Modernity in a 4-minute clip. Funny thing is about this, and the reason I showed it other than the comic relief, is that it almost wasn't made. This show was almost not produced. And the reason is that the Tennessee Williams estate refused to allow the original concept to be used, which was for them to do A Streetcar Named Desire as a straight play with the Simpsons characters. So the Tennessee Williams wrote Streetcar in 1947, And that was the same year, like, Meet the Press debuted, and that the first commercial TV dramatic series was broadcast. It was 45 years before this episode of Simpsons, and this year came on 9 years after Tennessee Williams had died. It would have almost been impossible for Williams to conceive of television at the time that we know today, and when he wrote Streetcar. But the power of copyright law is such that Williams, through his estate, was able to keep his play from being used as an element in an animated TV series almost a decade after his death. Now, the creative team ended up rerouting around this by writing some original music, and so in some ways the show turned out better than it might otherwise have. But, that doesn't always come to pass, and that sort of leads to the next story, and this is I call Homer Goes to the Opera. Again, another Simpson story. Lawrence Lessig, in his provocative book Free Culture, tells a story about filmmaker John Else and his documentary Sing Faster, a study of stagehands working backstage during a production of The Ring Cycle. As Lessig tells the story, during one of the performances, Else was shooting some stagehands playing checkers. In one corner of the room was a TV set. Playing on the TV set while the stagehands played checkers and the opera company played Wagner was The Simpsons. As Else judged it, this touch of cartoon helped to capture the flavor of what was special about the scene. Now let's take a look at this scene and see if you can see where...
And what the Rhine Maiden's done now is Albert is after them and after their gold.
He's trying to get the Rhine Maidens.
So here are the backstage crew playing cards while the ring cycle is...
Up on stage, the Rhine Maidens, the trolls, the giants, the gods are fighting and crashing about, and we're just downstairs playing cards. Just a little game of poker between scene changes.
So there's the TV shot.
Albert coming out of the stage right trap. Behind the stalactite there. And then another guy goes up the stairs. Do not follow the stuntman up the stairs. You just go out when he goes behind.
Do not follow the stuntman up the stairs. Okay.
What is that from, please?
That is from a documentary film called Sing Faster, which was a documentary on the behavior of the preparation of the stage of the ring cycle. It was by a guy named John Else. Now, first thing you may have noticed is they weren't playing checkers; they were playing cards. But you may have also noticed that wasn't The Simpsons that was playing in the TV set backstage. Years later, and this is back quoting Lessig's story, years later when he finally got funding to complete the film, Else was able to attempted to clear the rights for these few seconds of The Simpsons playing on this TV set. The Fox network told Else that it would cost him $10,000 to use that clip in the corner of a shot in a documentary about Wagner's Ring Cycle. Else did not have the money to buy the rights to replay what was playing backstage at the San Francisco Opera. At the very last minute, before the film was to be released, Else digitally replaced the shot with a clip from another film that he had worked on the day after Trinity, that he had finished 10 years before. How ironic. The same people who had to route around the copyrights of Tennessee Williams themselves turn around and keep a humble documentary maker from using a random 4.5-second clip of their show unless they received an arbitrary and capricious sum of $10,000. Maybe, of course, Rupert Murdoch does have a lifestyle to maintain, so that may in some respect explain that. So that's story 2. Story 3 is about a different Simpson. This is about O.J. Simpson, called Mr. O.J. and Dr. Juice. For those of you who were not on another planet at the time, in 1995, O.J. Simpson was tried for the murder of his ex-wife and her boyfriend. He was acquitted. This acquittal inspired 2 artists, Alan Katz and Chris Wren, to write and illustrate The Cat Not in the Hat by Dr. Juice, a satire of the double murder trial. This book contains such memorable verse as, A plea went out to Rob Shapiro, can you save the fallen hero? And Marcia Clark, hooray, hooray, was called in with the justice play. A man this famous never hires lawyers like Jacoby Myers. When you're accused of a killing scheme, you need to build a real dream team. Cochran, doodle-doo. Johnny, won't you join the crew? Cochran, deedle-dee. The dream team needs a victory. And of course, there's also the ever-sensitive and poignant one knife, two knife, red knife, dead wife. Dr. Seuss was not amused by this. Now, in truth, the good doctor had nothing to say one way or the other, as he had died 4 years earlier. Still, Dr. Seuss Enterprises LP, the owner of the copyrights for The Cat in the Hat, sued Penguin Books, the publisher of The Cat Not in the Hat, claiming that this satire was an unauthorized derivative work and therefore infringed on their copyright. Dr. Seuss won the suit, and the publication was withdrawn, and all copies of this were bought back and taken out of circulation. I was not able to find a copy of this anywhere. This is the only verse I could find available, and it's in the lawsuit. So, those three stories lead back to the agenda, where we'll now talk a little bit about these four musings. The four musings are this. Intellectual property is new, relatively new in the scheme of things. Second is that it's broad. In fact, today, all art is subject to copyright. That was not always so. There's also long. Copyrights today effectively last forever. That was not always so. And it's bad. This combination of broad and permanent copyrights leads to what I think of as a form of neo-feudalism. So, that's the four sort of musings that I want to cover and try to do this in a somewhat organized fashion. Intellectual property is a relatively new concept. In fact, in the law, in the common law, it dates back to the 18th century. At that time, there was a group of London publishers, booksellers, a group that were known at the time as the Congers. The Congers controlled the publication of all written texts in the British Empire. Now, the fact that these men were named after a species of slimy, scaleless eel gives you a sense of their general reputation. This arrangement was a very feudal structure. In fact, it was probably viewed as progressive, because up until the time the king controlled everything. This was probably a way for the king to actually maintain some sphere for the private sector in publication, but it was a very, very tightly held monopoly. Now, this state of affairs began to change in 1710 with the passage of what is referred to as the Statute of Anne in 1710, which for the first time put a time limit on copyrights. In that time, the copyrights were held by the publishers, by the Congers, basically in perpetuity under the common law. So legislatively, they passed the Statute of Anne. It was 14 years with the right, if the artist was alive, to renew for another 14 years. That was the length. Now, the Congers did not like this. They viewed it as the equivalent of a death sentence for their business. So even though they lost the parliamentary fight, for the next 64 years, they mounted a rearguard action against the Statute of Anne in the courts, trying to use friendly judges and usurping them to preserve their publishing monopoly. It's a good thing that kind of thing never happens anymore. Eventually, however, the Conger lost. In 1774, a scrappy Scottish bookseller named Alexander Donaldson won his court battle with the Conger, and for the first time, the law recognized the concept of a public domain, where works were placed available to all for no cost once the copyright expired. Now, this led to an explosion of both publishers and publications, a virtuous cycle of new readers and new writers and new publishers that helped fuel the intellectual ascendancy of the British Empire in the 19th century. Now, if you take a step back, property, you think intellectual property, this is sort of a strange notion. It's not clear why there should be property at all. I mean, this has been actually a much debated issue over the years. And when we do think of property, we tend to think of, physical stuff. And yet, in reality, property is not stuff. It is a legal construct. It's a basket of rights. And those attach to to stuff. And so, broadly speaking, this basket of rights is around to help define the way things will be used. And if you look at stuff versus non-stuff, these are, as you can tell, as a non-academic, these are non-technical terms. You have stuff and no stuff. In the category of stuff, you might have land, buildings, parts, etc. Non-stuff, you have ideas, intellectual property. And this regime of establishing rights, private rights to stuff, and no rights, which essentially left it for the public, is the current framework we have in categories for property. But this basket of rights are always limited. They always have been. And the reason they are is because the exercise of those rights always have impact on others. For instance, you may own a piece of property, and you may do what you want with it, but always limited. You can't come buy a piece of residential land and then turn it into a nuclear waste dump, right? You are prescribed from doing that because you create externalities by doing that. You have impact on other people's property. By the same token, if you have things where they're only held in common, right, where everything goes into the public domain, you have, or public parks or public property, you have a different kind of problem. And that problem is one of inefficiency, primarily. You have the tragedy of the commons, or the free rider effects that often come from public ownership of resources. The same, in mirroring that, you have a separate set of constraints and issues on the intellectual property side. And the key issues there are the incentive to create, right? This is a big problem in public domain. If an artist works hard to create something and cannot exploit that, then economically, over time, you will get an underproduction of art. There's no economic incentives to do that, right? I can just wait until someone creates a movie and then just make copies of it and do it and sell it myself, or works of art, or books, or music. So you have this big incentive problem that's created. On the other hand, if you just grant unlimited rights to non-stuff like copyrights and patents, you have a monopoly. And over time, it becomes economically inefficient as well, because monopolists don't share their profits, their consumer surplus, with the consumers. So this sort of framework is an important way to understand the property issues around that. The key in all of this seems to be a sense of balance, right? That you can't have fully private, you can't have fully public. You sort of get what I tell my students in class is the all-purpose Linbeck curve, right? That covers everything, right? I mean, if you have too much water, not good. Not enough water, not good. Optimal, somewhere in the middle, right? This also happens to apply for money, too, which is what I tell my MBAs. They almost believe it. Let's move to the next point. All art, my musing would say, is intellectual property, and that has not always been so. So how did this device of intellectual property come to apply to culture? Well, for the United States, it started in the Progress Clause, right? The Progress Clause, Article 1, Section 8, Clause 8, is that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. The Founding Fathers had this very clear vision of what the purpose of intellectual property was and the establishment of intellectual property. It was to promote science and the useful arts. It was to promote economic development. They saw that the way to do that was by granting exclusive rights for limited times. This is a very, very, it's amazing notion that they were that clear-headed about this at that time, because we still don't completely understand that. So this was the sort of starting point for intellectual property in the U.S. So what's been happening since? And on this, I rely a lot on Lessig's. I'm going to use some stuff from Lessig's book, Free Culture. There's a nice almost no art is intellectual property. The scope of this is very narrow. Okay, if you look back, in the 1790 was the Copyright Act, the first Copyright Act, which was the first statutory embodiment of copyright law in the United States. At that time, copyrights only extended to maps, books, and charts. That's it. Music, architecture, movies, photographs, digital content. Well, it was 1790, so those didn't apply anyway. But none of that was covered under the Copyright Act. It was maps, books, and charts. And it only covered the commercial realm. And it only covered the publication of stuff, copying and selling. It did not cover the transformation of that. Transformation being things like adaptation and redistribution of work. I could write a play based on a novel. That would be transforming that novel into a play. That was not covered. I had the right to do that in 1790 in the United States. Now, by 1900, this had changed somewhat. 1900, all commercial art has sort of been transformed into intellectual property. This happened in two ways. First was the expansion of the definition of what's covered. So music became covered, pictures, etc., became covered by the copyright laws. The other thing that happened was the realization that if I could take a novel and change one word in it and then claim this is new, that somehow that was betraying the whole point of copyright. So that was the thin end of a wedge that has increasingly been driven into the copyright law. Because if it's one word, that's not true. How about if I just change one phrase or one chapter? Or what if I change everything but one chapter or everything but one phrase? Until the point in time where essentially all transformations of art are covered under the copyright law, so long as they're used for commercial purposes. So in 1900, there's still just commercial use. Now, from that point, we started seeing more expansion in the law. And part of this was driven by technology. And what was happening was, in 1900, if you wanted to make a copy of a book, it was really hard to do, right? I mean, 1790 was really hard to do. But it's getting easier and easier and cheaper because technology is progressing and there's economic incentives to copy. So what happened was, by 1975, the non-commercial realm for publication was starting to be covered by copyright law. Because cheap copying technology, again, if I'm not making it for commercial use, perhaps to resell, but if I can make it for my own personal use, I don't have to go buy a book, right? So that might have been non-commercial at the time, but it's starting to impinge into the non-commercial realm by limiting what I can do for my own use. So that's the state in 75. Today, what has happened is, essentially, with the progress of digital technology, copying is free, right? If I've got a digital file, the cost for me to make a digital copy is basically zero. And so transformation, publication, commercial, non-commercial is right now covered entirely by copyright law. Now, there's an out. There's this thing called fair use, right? So I can use something fair, in a fair manner, right? But this is a really poorly defined term, and it ends up being litigated, and people have been sued. There was a student at RPI who was sued, accusing him of ripping off music, digital music, and he was sued for $150 million. This is a sophomore at RPI. I don't think he had the money. They ended up settling by agreeing. They agreed to drop the suit. The RIA dropped the suit in exchange for him turning over all of his life savings. He had actually not copied anything. He had written a software program that enabled a search of RPI's network systems. And that was aiding and abetting the stealing, theft, piracy of intellectual property. And he was caught in the middle of that. The problem with fair use as a doctrine is it's not defined in the law, so it gets litigated. And the cost of litigation is so exorbitantly high that as a practical use, someone coming in and relying on fair use is playing a very dangerous game. You can do it if you got a lot of money to defend yourself in court. If you don't, you're really stuck. And this is really what's come out in the last few years in terms of digital copyrights. So over time, second musing, the breadth of intellectual property law, the breadth of copyright law has expanded to basically cover all art. Third musing, time. So we've got breadth, time. What's been happening to the term of copyrights? The answer is they've been getting longer and longer and longer. Stuart Ostro, Frank Lesser, who was his mentor, once said to him, "Stu, producers come and go. Copyrights last forever." This is very much the view among today's creative community. My copyright, it's like my personal property. I get it forever, in perpetuity. There's a moral claim that's embedded in that, right? It's completely divorced from the reality of why intellectual property was developed in the first place. But that is very much in the mindset of the creative community today. So I've heard this described as old copyrights never die. They just lay in wait for their victims, right? Until someone comes along and I can grab a hold of that and take advantage of the person who's tripped over my copyright. If you look back in the length of copyrights, how long you could own a copyright, this is the progress. This is the chart. The original scheme, which started with the Statute of Anne, was a two-phase scheme. You got an original copyright, which you had to register, by the way. It was not assumed that you got the copyright just because you'd written it. You had to register it with the government. Then, at the end of an initial term, you had the right, if you were still alive, to renew that. Otherwise, it passed into the public domain. So we see the initial term, and we see the total term if you assume renewals. By the way, in this time period, up until about the date of, I think we have like in 1950, about 5% of copyrights were renewed. Just 5%. So most people, they registered a copyright, and at the end of, however many years in the initial term, 28, they just let it lapse because it wasn't worth it. Most art and intellectual property has economic value for a very short period of time. It's just the facts. If you look at the income-producing value of a work of art. So back in 1790, we had our first regime in the United States, 14 years with a 14-year renewal, just like the Statute of Anne. That was expanded in 1831. In 1831, what happened was they said, well, let's expand this to 28 years for the initial term. We still have a 14-year renewal. And then that stayed for a while. Then, in 1909, they said, well, let's do a 28-year renewal. So now we're up to 28 and 28, so we can get up to 56 years. Then, and this is a huge sea change in the law, 1975, they abolished the two-tier system. Before that, they had extended, you'll see, this to 57 years, I believe. But that was very brief. Then they abolished the two-tier system. Basically, and they did two other things in addition to that. They changed it so that it was tied to the life of the author plus a period of time, right? So right now, or in 1975, they made it the life of the author plus 50 years, okay? I've chosen about a 40-year life expectancy here in terms of the average author publishing by 30 living to 70 or 40 living to 80. That's going to be short. It's going to understate this for the current generation of artists that are in their 20s and 30s and 40s, because medical science is such we're going to live longer and work longer. It's just reality. So, but I've used 40 years, so they extended it to the life of the author plus 50 years, and then the other thing they did, they abolished the two-tier system. So you got the full copyright just by creating the art, which is the other piece is they removed the registration requirement. So you got your copyright irrespective of whether you registered with the government. It was just awarded to you for writing something on a piece of paper. That's it. It required no more. So then that was, in 1998, expanded with the Sonny Bono Copyright Extension Act, also known as the Saving Mickey Mouse for More Disney Profit Act, to 70 years, life plus 70 years. So you ended up with this really expansive lengthening of copyrights. The reality is that given that this is set by Congress, right, without some kind of a prior constraint on it, there's no reason to believe these copyrights are ever going to expire. We will go forward to 2030, the year before Mickey Mouse is now set to expire, and I have a good sense that somehow the people whose interests are benefited by this will find a way to extend the copyright again. The reality is between 95 and 98, or 75 and 98, the law has extended or changed or morphed or adapted or broadened, I think, 13 times, right? And each time it's been a coalition of rights holders, and this is classic political analysis. Concentrated benefits, diffuse costs. This doesn't take money out of any individual's pocket. It's very diffuse, but you have very concentrated benefits. So their incentive is to try to use the political process to benefit themselves, which is the way it works. So why does it matter? Why shouldn't creators of art just have a sort of a permanent ownership of this that passes on to their heirs and their heirs' heirs' heirs? And for this, I want to try to use a framework to help understand the creative process. And this is one that was adapted from one of my teachers at Stanford, a guy named James March. And he had this concept of progress and organizational development as being a balance between exploration and exploitation, right? Two modes. In art, we're constantly using what's been done before to build on, right? Shakespeare wrote Henry V, right? But he relied on Raphael Hollingshead's work on the Chronicles of Henry V, right? I mean, he added stuff, the Agincourts, Crispins. He did some good stuff on top of that, right? I'm not jamming him for that, but the fact is he still relied on the basic story components that were in Hollingshead's Chronicles. Then, another example, Aaron Copland. Strongly influenced by American folk music. Some of his most compelling work lifts American folk music into it and then adapts it, adding modern rhythms, syncopation, and really created a new and distinctive musical idiom by doing that. But he exploited folk music to do that and then explored these new expressions. Picasso, another great example. He was clearly an outside-the-box genius and built entire schools of art. But he was strongly influenced by African art. It is difficult to look at some of his most famous Cubist paintings and then look at some of his most influential, some of the most influential African masks that he had copies of, and say this was not a profound influence. It was very profound. So he exploited this tradition of African art and masks and the symbolism that was embedded in that. And yet he exploited that and explored a whole new way of expressing that artistically. Now, I could go on and on in this, but the fundamental point is there's a synthesis here. There's an equilibrium between exploration and exploitation. One way I've seen this expressed very well, there's a popular author, a guy named Jim Collins, who puts it in this framework in terms of the development. You're preserving the core. You're building on what's gone on before, but you're stimulating progress. You're always looking and exploring new avenues. And it's that equilibrium which is really, really important to progress in this area. So if art is going to thrive under a copyright regime, that regime has to balance and support both of these modes, the exploration and the exploitation. It has to reward new ideas and concepts, and yet it has to allow you to use the old. Right? This is the tension. So if we allow very long-term copyrights, effectively permanent, that undermines this exploitation process, where I'm borrowing from and building on what has gone before me. Now, really, if you add into that no registration, so even if I'm legally required to go and get someone's permission to do this, if I can't even find them, right, because they're not registered with anyone, and the only way to enforce my right to do that is to go to court under a fair use doctrine. This is really, really not a good situation. So in trying to think of a simple analogy for this, and then I want to get to the final piece, I try to think of this as crossing a river, right? I mean, if you're in a situation where you're trying to cross a river, let's think of this idealized world. We want bridges across this river, right? We want to explore what's on the other side. But, if I go and bear all the cost of building the bridge just for my own use, I'm probably not going to build a bridge. I'll just hang out on the other side of the river. So we want to encourage bridge construction. So we get those people, that build bridges, we give them the exclusive rights to do as they see fit with the bridge, okay? So they can limit access, they can charge, it becomes their property, right? Now, under this regime, we'll get bridges built, right? And this is a good thing because we can then get to the other side of the river. And for a while, this works great. But because we start building, after that first bridge is built, it's easy to build follow-on bridges, right? Because it's easy to get to the other side now. And you can take stuff across the bridge and then build a bigger bridge. And you can take more stuff over. And And this stimulates a whole period of bridge building, which is great. And it's, you know, as long as they're, I'm leaving aside the aesthetics of bridges for just a second. Okay, work with me here. Eventually, over time, the number of sites shrink. We don't have good places to build new bridges. They're not adding a lot of incremental value, and the number of bridges tapers off. Then what happens? The bridge owners start thinking, well, what's the best thing for me to do with my bridge, right? I keep competing against these other people who also have bridges. The next phase of this is naturally a consolidation in the ownership of bridges. Mergers, acquisitions, combinations, until the point in time when they have all the bridges under one control. At that point, right, you start getting monopoly pricing, and the consumer starts paying more and more, and less bridge crossing takes place, and there's an overall negative impact on economic development. So, the solution, the classic solution to this is after some period of time, these go into the public domain, right? You have the opportunity, you have a limited license to build this bridge, you get to do whatever, get as much as you can during that period of time, and at the end of that, it goes into the public domain. It's owned by the public. So, in analogous fashion, the term of copyrights is really critical. If we don't limit the term of copyrights in a real way, then we will switch from what has been called in the past a free culture, which doesn't mean like free beer. It means free like, you know, I'm unrestrained from making open dealings in the marketplace, to a permission culture. And this is not a good thing. And the Founding Fathers knew this, right? This is why they put limited times on these things. So, final musing gets to this concept of neo-feudalism. This state of affairs that I just described with the bridge crossings is exactly what we're heading into now. We have this intellectual property regime that's very broad and grants effectively permanent franchises. We have no copyright registration requirement, so even if you wanted to track people down, you couldn't. And we have large, well-funded companies that have acquired large portfolios of intellectual property. And they're ready to fight to maintain its value. If you have ever been on the other side of a dispute with Disney over copyright, it is vicious and expensive. So if this continues, it will be virtually impossible to undertake any creative project without getting permission of some existing copyright holder. And increasingly, this is concentrated in the hands of fewer. And that will be not good. That will essentially create a new feudal order, right? Where a handful of lords, the new lords of the manor, these concentrated copyright owners, will be able to exert more and more control over the content. And you will have replaced a king, as they had before, and the conger, as they had before the Statute of Anne, with a self-selected group of copyright lords. This would be a tragedy, in my opinion, for our society. So, that's kind of depressing, we go through this. So, what do we do about this? Well, this is a problem. One of the things that, I mean, I'm not by nature, I didn't sort of figure a lot of this stuff out until actually Dan asked me to talk about it. So, but I'd seen all of this, and in response to this, actually a while back, Stuart Oster and I had been working on this concept of open source musical theater development. And that's the model I want to share with you. Some of you may be aware of open source software development. Linux is the most famous. Apache, if you've surfed on the web, you have almost certainly gone through an Apache web server. This stuff was developed using an open source software model. And the way that worked was that a bunch of people all over the world literally contributed software to these projects for free. And they had copyrights under what's called a general public license, and under that license they contributed their software to these projects. And from that, Linux, this incredibly robust professional operating system was created. And it's just an example. Linus Torvalds was the sort of ubermensch of this whole process, and all decisions of what was included or not went through Linus, right? This sort of 35-year-old baby-faced guy in Finland. It was just kind of a historical quirk. But this software development model has been incredibly powerful. What we're trying to do is use that model to build musical theater. So we've established this freemusicaltheater.org. The website is supposed to go live in January. It's not live now. If you go to that, you won't get anything. You might get sort of pointed. You won't get pointed to a porn site, but no telling where you'll go. The idea is to create a place where people can come and contribute to theatrical development on a general public license basis. So Stuart has a project that we're currently working. He's actually made some progress offline with. We're going to post the storylines, the concepts, the overall production concept on the website, and anyone who wants to contribute, scenes, language, music, lyrics, production design, lighting design, costume design concepts, anyone who has ideas on how to produce it better, they all can contribute. The key is they're assigning their intellectual property rights to this thing, right? And then once we're done, anyone who wants to produce this show is free to do it. It's open source. And the idea is by harnessing what is relatively new technology through the internet that allows us to digitize all the stuff I just talked about. I mean, there's these tools now where you could do choreography in 3D on the computer, which is wild, right? So anyway, we're going to try to use that as an organizing principle to basically give people who otherwise have no way to get musical theater developed to contribute to something, and then we're going to produce it. And we're going to do it in Houston, in the Hobby Center for the Performing Arts, probably in the Zilka Theater. And our concept is to use this as a new model. There's in open source software development, there's this thing called SourceForge, which is the organizing site for open source software development. And our aspiration is to become the SourceForge for musical theater development. And just so you know, Stuart is a pretty amazing guy. I mean, Dan gave some, but I mean, Pippin, 1776, and then Butterfly were all Tony Award winners for Stuart. He also was the guy who fixed Chicago for Bob Fosse, and that's a whole story in and of itself. He was involved with Frank Lesser and some of his bigger stuff, and started working for Frank. So all contributions to this site will be subject to a Creative Commons license. If you haven't checked out the Creative Commons, that would be worth your time in this area. And the idea is to open up new bridges across this river and spur new creative ideas from unknown and untested artists. That's what's driving this. The money that will be made from us producing this show will be recycled back into the Institute, right? So the idea is to use the production of these shows as the economic driver of progress. I found out this morning this register is not up yet, but it'll be up next week. So if you are interested in seeing this, send an email next week. Don't do it today or it'll get bounced back. Final point and wrap up on this. This broadening and lengthening of copyrights is a risk to our culture. I'm convinced of that. The concentration of ownership could result in a sort of a cultural neo-feudalism, and we need new models. This is the main thing. We're harnessing existing copyright law to basically set up a competitive model with the statutory regime and to provide a counterbalance. And the title of this talk is Let's Kill All the Lawyers, and that's, those of you who don't know, that's from Shakespeare, Henry VI, right? It's often used to sort of say, well, lawyers are the problem, let's kill all the lawyers, right? But if you go and you look at Henry VI and you look at the context in which that was used, it's actually ironic, right? Because it's spoken by a character named Dick the Butcher, right? And they're imagining this idyllic world, right? That is just, it's perfect, it's utopia. And Dick the Butcher says, first, let's kill all the lawyers. Right? That's first thing we do, let's kill all the lawyers. And Shakespeare's point in that, Shakespeare, by the way, was no naif when it came to intellectual property. He protected his rights. But I think Shakespeare's point is that what we need is a balance, right? The lawyers can't run crazy, but if you wipe lawyers off the face of the earth and you get rid of the rule of law, that's just as big of a threat. And that statement was in the context of him debunking this idea of a utopia. And so the focus of this, and actually the idea behind the title, was to promote this idea of competition of models, balance in the system, and something that will help progress the arts, not be an impediment to it. So that's it. Thank you.
Leo is open.
Yes.
I found your argument is extremely compelling. And I have only one question here. I think that, and I believe you would say the same, that the working artist during his lifetime should indeed be protected in terms of the intellectual property. And a reasonable, I think even 50 years is a little on the long side, after the death, maybe 10 years. Do you think there would ever be a reversal back to that kind of concept? So that a person could reap the fruits of their labor, on the one hand, during their lifetime, a short period after the heirs, playing back against this totally open-ended situation?
I mean, I think there could be a regression. I don't see that. I see everything going the other way. And maybe this is because I spend the most of my time in the arts world is spent in musical theater, where it is the tyranny of the artist. I mean, if you read the Dramatists Guild agreement, it's appalling. I mean, and so what's happening is that there's this huge siphoning off of talent going into musical theater because there aren't enough producers to produce this, right? I mean, Stewart is in some ways the last of his kind, of the lone wolf producer. Now everything's done by these corporate consortia that have already secured the rights by publishing it in other areas first, right? So anyway, the short answer is I think there's very little danger of that kind of retrogression. What there could be are competitive models of that say, look, if you want to get into musical theater, you know, and you want to go through freemusicaltheater.org, you're gonna have to assign your intellectual property rights to get started. And that you can view that as exploitation. You can also, in just the same way you can view paying graduate students, you know, $3 an hour exploitation, right? But there's a learning that's a part of the trade in that.
I bring this up only because there is a problem in the visual arts, so that public monuments are frequently displayed in newspapers or in magazines, and they'll talk about what the monument is about. They don't name either the architect or the sculptor. And that's a way of denying them street publicity, if you will, at the very least. But it also is against the law in some states because reproduction rights, and that is a form of reproduction, are supposed to reside with the artist. Now, this is a little different from...
Yeah, no, but this impacts movie production very, very much so, right? Because basically... this is why people do most of they do a lot less location shooting in areas where these rights exist, right? They either build studio sets, in which case they say, look, we built the studio set. We're not ripping this off, it's different. Or they just shoot in areas where those rights don't exist. And so to me, that right, where you have someone who's built a sculpture or has designed a building, and a movie maker can't include that image in their movie, to me, it's appalling to me. I mean, I'll be honest with you. And I understand their perspective on it because they feel like that anyone who looks at what they're doing should pay them money. I just find that ridiculous. That's for me. So we have democracies. I mean, it'd be scary if I was a dictator, I know. But sorry.
Following on that point, you have the case of Frederick Hart, for instance, with The Devil's Advocate, where his art was pornographically distorted, even though they didn't use his art, they created their own thing, but it was an obvious allusion to that. So where would you find the balance? I mean, it's all prudential, right? But
it's all prudential. I think from a legal construct, I would be concerned about limiting the right of the pornographer to do that. I'll be honest with you. I think it's appalling that they do that, but I think it's appalling that they do pornography. And to try to change the law in some way to undermine in ways that will undermine legitimate use and reuse in order to go after those guys, I mean, people misquote things I say all the time. You know? It's only life is. I don't know. And I understand why there's anger associated with that, and I appreciate that, but I just don't think constraining it in such a way is good for the culture overall. I mean, it's not like it's going to make pornography go away, right?
right.
Well, it strikes me that this equilibrium you talk about between exploration and exploitation But from the marketing side, it seems a little bit more troublesome, at least until the point where you change the world and you have these sort of this open source model totally operative. Because you know, if you take a writer who's trying to market a manuscript, if he doesn't have copyright up front just by virtue of having written it, and he's showing it around most often simultaneously, as you know, the less reputable members of that industry are going to poach on that idea, or he's always vulnerable to that. So if he doesn't have protection up front in a kind of more straightforward market model, it seems to me that that's a problem.
Well, and I wouldn't argue for abolition of copyright, right? It seems when they abolished the registration process at the time, it was $30 to register a copyright. So let's say that through information technology, that ought to be on a current equivalent curve, $10, $15 a day, right? I mean, this is ought to be something you can do through a website, right? I'm going to register my copyright, and that's it. I mean, even with registration, I mean, I think that enhances the situation, because then you've got public notice, right? It's like, hey, I posted it with the government. I posted it on this date. Here's when I met with you, and here's where you ripped me off, right? Whereas they're like, well, we didn't get that, or I don't remember that meeting, and there's all kinds of budgie around that. So I think registration helps that process. The other thing is, from a marketing standpoint, the value of your property, right? I mean, just economically speaking, is gone in a decade for all practical purposes. So if you had 14 years of protection under the old system, the founder's copyright, with the right to renew for another 14, 28 years, I mean...
Yeah, I'm thinking of a situation where you don't have any chance to make a buck on it because your idea is stolen and you get it.
Well, but the length of term of copyright doesn't impact that. It's just the way that the copyright is enforced, right? Because whether you have that right for 100 years or 15 years, if it's not enforced, it's not enforced. And I think registration would help that.
Let me tell you a little story that might illustrate what I think might be a sort of invisible hand solution to this. I've edited a law school textbook, and it's a health law book, and so we were negotiating with the New England Journal of Medicine and the Journal of the American Medical Association. New England Journal of Medicine wants $25 for any article that has ever appeared in the New England Journal. That's it. Okay? JAMA wants $150. So we had about 6 articles from each. Guess which 6 articles got dropped? Okay? We substituted 3 more articles from the New England Journal, had 3 others somewhere else that said roughly the same sort of thing. And so, it's not that the New England Journal made a fortune, but JAMA didn't make a nickel.
And there can be ways of regulating. There's this same kind of, this tension can be relieved in different modes, not just this. I mean, if you think about the way that artists, performers of music are paid, right? I mean, under the copyright laws, right, the artist who performs a song that gets played on the radio gets nothing. The person who wrote that song gets paid a statutorily defined royalty payment, right? And that's set by the government. And I don't remember what it is, it's, X. So the performer gets nothing. And in that situation, right, that to me makes sense as a balance, right? Because the performer is getting a sort of promotional benefit of playing on the radio, whereas the guy who wrote the song is getting nothing unless there's some kind of way to do it. And Congress sort of realized this, and they imposed this sort of broad single, and you can argue, well, it ought to be higher or lower, and they're always negotiating around that, and economists do studies on that, but that's a nice balanced regime. And I think those sorts of coming up with those kind of balanced regimes are a whole lot better than a guy who has a 4.5-second clip who goes to Fox and says, you got to pay me $10,000.
Well, then Fox doesn't use it.
And then, yeah.
Well, I mean, my son negotiates copyrights for VH1. Okay. So he's really in the business, which I'm not. But there's lots of stuff that gets dropped out of the Jimi Hendrix special. Okay, because it was too expensive. And
or you couldn't find people too. This happens particularly with actors, right? Who you have to get their clearance to use. Like, have you ever seen? You guys all watch Cops, right? So if some of the faces, are kind of blurred out, those are people they couldn't find to get them to sign the right, the clearance, the right. So you see the blurry faces, and you're thinking, well, they just didn't want to be known. No, they just couldn't find them.
Yeah, you mentioned the Creative Commons license. I have two questions. First, do you think that's an ultimate solution to the problem? And B, do you think it has a legal leg to stand on since, as I understand, and I could be wrong, but the minute you abridge your copyright protection, you forfeit it?
I'm sorry. That's not quite right, okay? Because what happens is if you abandon your copyright and it goes to the public domain, then you're toast, right? What Creative Commons has done is it's created alternative copyright regimes where I can choose to assign. By owning the copyright, I essentially have an unlimited right. So what you can do is you can choose one of their flavors of copyright, and you choose to restrict the rights you're going to enforce. Right? You can choose to enforce none. You can choose to enforce some. You can choose to turn it into the public domain. Right? But you're not limiting your copyright by choosing that license. Right? It's like if I own a building and I lease it to someone, he signs a lease and he can do stuff under that lease. There's still rights I have that I reserve for myself. And the fact that I lease it to that person does not impair my fundamental rights that are part of the property code. So I think the Creative Commons solution is a very robust and solution that will work. The challenge is that, like in musical theater, our big challenge with Creative Commons, they don't have the flavor. We're working to come up with a different assignment of rights, because part of our concept is that, for instance, if you submit a song to be included in one of our shows, you have to assign your rights for the use of that song to the show, for the show. But you can retain those rights if you want to go cut your own CD and go through traditional music channels and sell your music, right? And so what we're trying to do is bifurcate that to create space for people to create shows, musical theater, which then can be repurposed and replayed for free or reperformed for free, right? I mean, you probably don't know, but musical theater, there's stock rights, and if a high school puts on a performance of the Music Man, they have to pay money to Frank Music, which owns that copyright, and some of those fees are expensive, and so you don't get a lot of that stuff produced. So we're trying to create a vehicle where people put stuff out there, and then the new artists that come up through our program, they'll get on someone's radar screen, right? I mean, a producer's going to say, oh, wow, you did that work. Well, why don't you work with me on this show? And they can do it through the traditional channel and keep the rights. And we're not trying to say that's wrong. We think it's wrong if it covers everything, and there's only one regime. There ought to be multiple regimes.
I'm just wondering about the motivation of the. I like the idea.
But why would somebody be so stupid as to?
Yeah, I write this wonderful little ditty and I give it to you, and suddenly, Elton John's performing it, and.
Well, I mean, this gets back to sort of the question of derivative or alternative uses, right? I mean, part of the tyranny of the current system is that the expanse of technology, the growth of technology, usurps new rights into the old system, right? So, I mean, when they wrote the copyright law in 1975, the concept that you could digitize an entire film and put it on a disc, I mean, there were a few people who were thinking that, but it was pretty out there, right? And so, but what's happened is now all that's gotten subsumed. So Elton John may still not be able to perform your song, right? You can still reserve re-recording rights and keep, some of the mechanicals associated with it. But if we put it in the show, we can use it for free. Now, the reason people do this, our hypothesis is they'll do it for the same reason people contribute open source software, right? Because you say, well, why would you write free software and give it to these guys who don't make any money and don't pay you anything? I mean, that's a good question. And the studies that have been done on this is the number one reason people contribute, credit. It's credit, right? Which, if you've been in show business, you also...
May I have your attention, please? The time is now 3:10 and the end of the current session. We have a couple of announcements. There'll be a book signing by Professor Michael Scaperlanda in the book room. He'll be signing his book, The Journey, A Guide for the Modern Pilgrim. Also, the people taking the Snipe Museum tour should be at the Snipe Museum by 3:40. It's building number 54 on your campus map and a quick 2-minute walk from this building. Thank you.
So the guys contribute that to get credit, which has two impacts. First of all, sometimes just the credit is all they want. I mean, think of the number of artists that get stiffed on credits, and it really hurts, right? You have poured yourself into it. You at least want people to know you've done it. But then the other thing is you monetize credit, right? Artists know this is what they want credit too, right? Because if I've done this and you can show me the credits in the boy, that makes you much more credible with the next thing. It's building a portfolio. So we think that'll be pretty compelling. Now, honestly, would they do that for Leo Linbeck III? But for Stuart Oscar, I think they will.
So you mentioned recently that there's the fair use clause and it's not defined. It seemed to me, I don't know much about it. It seemed to me like if they define what fair use is, then it might solve a lot of problems.
It might, but it's a devilishly difficult thing to define, right? I mean, so let's just do music. What's fair use of music? You buy a CD. How can you use that fairly? Can you? One thing that's clear: you can't make a copy of it, and take it down to the corner and sell it. Right? That's not fair. But what if I rip a really cool single off of it and send it electronically to a friend? Right? Was that fair? I don't know. The friend on hearing that may go buy the album. Right? So you could say, "Gosh, I'm actually helping get this music out," or you could say, "No, you ripped me off." I mean, that's a relatively simple example. What if you want to take that song, you want to rip it, you want to include it in a documentary film on finding a cure for AIDS, right? You might say, well, that's a really noble purpose. And can I take that song and put it as a background track with that? It's a perfect song. It's just what I want. But, should I be allowed to do that? Is that fair? It's really difficult. I mean, part of it is fair in and of itself. I mean,
well, I understand that it's so broadly defined right now that if they just narrowed it down.
If you narrowed it down too much,
right? I'm not.
Right, where the only fair things you can do, right? This is the problem. If you make it so narrow that the only fair things you can use are very tightly subscribed, then it loses its creative value.
Thank you, Leo.